Hello, everyone, and welcome to today's webinar, Legal 101, presented by Bodman and Early Growth Financial Services. My name is Amanda Young, and I'll be your moderator today from the EGFS team. And I just have a couple of quick notes before we get started. This webinar will last about an hour, and that'll include time at the end for questions and discussion. So you can feel free to type your questions in as we go, just in the control panel. And if we don't get to them during the presentation, we'll answer them at the end. The next thing to note is that this webinar will be recorded, and we'll send the recording to all the registrants along with the slide deck within at least 48 hours. You can also find this recording and all of the recordings of our webinars at our YouTube channel, which is Early Growth. Now, before I pass this off to our panelists, I just want to tell you a little bit about EGFS. We're an outsourced finance and accounting firm. We work with early stage companies, and we help them with everything from day-to-day accounting to financial forecasting to taxes and valuations. So now, without further ado, I'd like to introduce our panelists, Joseph Morrison and Michael Melfi, who will tell us a little bit about themselves, and they'll kick off today's discussion.
All right. Well, hello, and thank you so much for having us. My name is Michael Melfi.
And I'm Joe Morrison.
And we want to thank Early Growth Financial Services for having us. Joe and I are from Bodman, and we're looking forward to talking with you today about the 10 keys for day one. And we came up with this because we got a lot of questions around what issues do entrepreneurs face? What issues do early stage companies face? And we wanted to come up with a nice, clear, concise way to talk through 10 items that we feel are the most important to address early on in an organization and a business's career. So what we'll do is we'll take a quick introduction, tell you a little bit about ourselves, and then we'll hop right into the 10 key fundamentals, and from there we'll do a Q&A. As Amanda had said, please feel free to put your questions in the chat. If we can fit them in, we'll definitely answer them. Otherwise, we'll save them to the end, and we'll make sure to answer anyone's questions at the end. Real quickly, a little bit about us. Bodman is one of the Midwest's leading firms, business law firms. We provide counsel to some of the most successful companies and individuals across a broad range of issues. Joe and I happen to specifically work in the emerging companies and venture capital practice group. What that means is we work with a lot of startups and emerging companies. In any given year, there are hundreds of clients that we work with to assist them in a broad range of issues that they're facing when they're forming and growing their business. We work with them and to understand not just the legal, but the non-legal, the commercial and strategic sides of their business. And we always look to provide a pragmatic, down-to-earth advice to our clients outside of that traditional legal realm. So with that, we'll go ahead and hop right in with the 10 key items for startups, 10 things you need to know. So the first one, and I'll dive into, and then I'll let Joe grab the next one, is what are you? So really understanding what your organizational structure is, whether it be a corporation or an LLC, whether you're going to have B Corp status or an S Corp, really understanding what goes with that. The ones that are most commonly talked about typically are an LLC or a corporation. And so as you get in that and determine what you are, you also want to understand what you have. So if you're a corporation, you're going to have shareholders, you're going to have directors. Whereas if you're an LLC, you're going to have members or managers. You're typically going to have, with a corporation, shares, whereas with an LLC, you're going to have units. So understanding the structure is an important first part. You're also going to want to make sure you have the right documents. If it's a corporation, you're going to have a shareholder agreement. If it's an LLC, you're going to have an operating agreement. And quite often, the first question that pops up says, well, what's the difference? How do you determine that? And really, probably the biggest thing that we typically look at is the tax implications and the type of funding considerations. So if you're looking to ultimately get venture capital funding and your business is going to go that route, then you're going to want to set it up as a corporation. And that would be important to look at that way. And again, that's the part of the early on analysis that we typically do with our clients to understand that.
And I think it's important to note that the choice of being a corporation or an LLC really depends on, what the next 12 to 18 months look like for your specific company, both from a tax perspective for the owners of the company, but also, as Michael mentioned, financing, how you're rolling on employees, how you plan to finance the entity. So, a lot of different considerations that you really want to think about before you go down the path of being a corporation or an LLC. one key thing is that an LLC can convert itself into a corporation when you need that to happen. However, that's a one-way door. A corporation cannot go back to being an LLC or change itself to being an LLC without often seriously adverse tax consequences. So do note that you'll see a lot of startups, especially in the med device or the therapeutics or the biotech space, that start out as LLCs. And even though they intend to raise venture money, they're LLCs to start it with the understanding that they will become corporations in the future. Another consideration is whether you're a corporation or an LLC is a question of your legal structure. You also form your company, whether it's a corporation or an LLC, in a state. So where are you is the next question after you determine what type of company you want to be. You'll see the vast majority of companies that raise traditional series financing, Series A, Series B, equity rounds, are Delaware corporations. And that's because Delaware corporate law is the gold standard that venture capitalists and many other types of financing sources expect. So we are based in Michigan. We see a lot of Michigan LLCs. We see a lot of Michigan corporations. But if you plan to raise venture money or you are going to be a venture-backed startup, expect that you will end up as a Delaware corporation.
Yeah, and I think it's, that's probably the biggest factor because, we work with companies from around the country, and sometimes someone will say, well, I'm in Arizona, or I'm a Florida, or I'm a Texas. I was just dealing with a client this morning that was in Texas. And if you're not seeking that venture funding, you can be fine working and ultimately having your entity set up in an individual state. It could be Illinois, it could be California, it could be New York. It's fine whatever you ultimately do choose. It's just if you are going to go for that venture round, most are going to typically push you to being that corporation in Delaware. And so we find that quite often. And ultimately, there's a lot of advantageous reasons why you may be in different states for tax purposes. But from a venture capital standpoint, that's where they're going to want to see you ultimately positioning your company down the road. The third key we talk about is what do you have? And ultimately, what we're asking about is what is your core asset? If it's a service-based business, then typically it could be the talent and the execution. That's what you have. That's what you're delivering. That's where the value is. If it's a product-based business, it's traditionally and probably intellectual property that you have. And so when we're talking to clients, a lot of times we really want to understand what is their business, what is their product or service, because in doing that, we can begin to understand a lot of different things. Mainly how we're going to protect the assets, the core assets of the business, which we're going to do in the future slides. We're really making sure understanding what that is and where that is will help us really devise the proper legal strategy in the months and years to come for the company.
And so this is key number 3 because you're often forming a company, whether it's a corporation or an LLC in Michigan or Delaware or otherwise, to protect and start to commercialize an asset. So this is really a question that you want to ask very early because, like Michael said, it does inform a lot of different parts of your strategy on how you will spend your legal dollars, how you'll spend your time, and really some of the very earliest stage documents that you would put in place to either engage employees or third-party service providers or otherwise.
Yeah, when often I'll find when we're working early on with a company or we're onboarding them to start working with them, one of the first things I'll always do is I will ask them this question because it really gives me a framework for where they are going and what type of obstacles they're going to face either from a legal, operational, or financial standpoint down the road. And so that besides getting to know them and understand them and their entrepreneurial spirit, it's to understand legally how we can ultimately protect them down the road. Because once we have that in place, we can really begin to look at the fourth key, which is what do you have? Which typically, when we talk about intellectual property, most people just immediately go to a patent. And there's so much more than just that. So there's really 4 major areas of IP or intellectual property. The first being trade secrets, the second one trademarks, the third one copyrights, and the fourth one patents. And really at a high level, when we're talking to someone, we're looking to see, is there an IP asset that we can protect? So, is it a name or a logo? We're more than likely going to do a trademark. So that's typically the most common question we get is, can I protect my brand? And that would be through a trademark. We'll also get questions about, how do I protect, maybe it's a website, or maybe it's a work of art, or it's a collective work of art. Maybe it's a marketing brochure or some other literary materials. That typically falls under the terms of copyright. You'll often see on a website at the bottom, it'll say copyright in 2018. Or when you're watching a video, those videos typically are copyrighted. So you will get the copyright around those types of content for your business. The patents, typically, you're looking for something that's novel, non-obvious, and unique. It truly has to be distinctive and disruptive, and you're looking to commercialize it. It is then that you can go down the route of a patent and the process that goes into doing all of that, whether it be starting with a provisional and moving to a non-provisional, a design patent. It really will depend on the strategy that does go into that. Those are typically the more complicated and more expensive of all the IP, because it really gives you a license from the government to basically protect and defend your idea against anyone else trying to manufacture or sell it in the United States or potentially the world, depending on where your filing occurs. The last one is the trade secrets, and as the name says, it's a secret to your trade. The idea around this is taking something and wanting to protect it. So, the most common example I give is the Coca-Cola secret recipe. There are two people in the world that know that recipe, and they're never traveled together. And Coca-Cola goes to extreme measures to protect that trade secret, to keep it proprietary to their business and keep it as intellectual property.
So IP is critical. So anyone who is, really looking to scale, especially venture backable startups, not only do you need IP, but you need a compelling story as to why the IP is valuable, how you are defending it, and how you really plan to monetize it. So if not good enough that you say, I have all this valuable knowledge, you really need to frame it as, I have a valuable brand, I have a robust trade secret, I have a patent, I plan to exploit my IP in XYZ manner. So, what are your core assets? And then what specifically do you have is essential in order to either attract funding or honestly attract high-level talent that can help you monetize the types of IP that you have. So who is helping you is the fifth key. So after you've figured out what your assets are and what your intellectual property is, you need to figure out what it means to have a team and who is on the team. When you figure out who's on the team, you also need to figure out in what capacity they are helping you out and contributing to the company. So very often we see in early stage startups that they have a CEO, a CTO, a CMO, or a COO, but we're often coaching people to make sure that they have a well-rounded team. So that is not just filling out the C-suite. And, if it was a baseball team, you're not only going to have people that hit home runs, right? You need to make sure that you have the business side taken care of, the technical side taken care of. You have both, C-suite, high-level employees. You have more worker bee type employees. And then you really want to be diligent about managing equity grants or just compensation more generally. So our third sub-bullet here is keep your cap table clean. So when you look at your team and you decide who's on it and in what their capacity they're helping out, you really want to figure out how to compensate them as required by law, but in a way that is favorable for the company. So we'll talk a little bit more about compensation, but seeing who's on your team and in what capacity they're helping out and how you're compensating them is another really important early stage evaluation and strategy point.
Yeah, and I would say, it's so often people will come to us and they'll start talking about their team and they got, 3 other co-founders, and all of a sudden we're going to, give them all C-level executive titles and break up their company and give it all away. And equity can be very valuable. You don't want to just necessarily give that away. And so really being able to identify what that means to be on the team is important. We'll all spend quite a bit of time getting to understand what does that mean to bring someone on the team and how we're going to incentivize them to stay around on the team as part of that. And so we'll often look at who is helping you and are they integral to the growth of the business, and then how you want to compensate them for that. Because so often, people just say, hey, I want to set up some vesting, or hey, I want to bring this person aboard. All roles are important, and there's certain ones that are vital to the growth and success in that business, because if that person were not to be there and you had to bring someone else in, someone has to step in those shoes and be able to move forward and really carry the company forward from whatever that position is. And it's not something to be just taken lightly when you're just saying, hey, we have all these team members, and making sure you actually have the right people on the bus so you can be successful. Because ultimately, if the goal is to scale and grow and seek investment, the investors are going to be looking at who is this team that's going to be executing, and can they execute, and how are they being incentivized to execute.
So, who's helping you once you determine who's on the team? You also need to be diligent about certain details, like how are they classified under applicable law. So this is the classic Uber question, right? We see a lot of startups that say everybody who's helping me is a contractor. Well, that's not something you get to choose. So the law, and there's obviously very robust set of law that Uber and others are running into, that tells you how somebody should be classified. So it is not a choice of I can choose for you whether you're an independent contractor or an employee. What we do with our clients is we help them go through the substantive details of what somebody is doing for the company, when they're doing it, how they're doing it, and that results in their classification. So just because you have someone sign a consulting agreement does not mean that you have correctly classified them as a consultant. And the IRS has a 21-factor test that is very wishy-washy and focused on the economic realities of the relationship. So this classification is very, very important, because getting this wrong can be expensive. And we did this presentation last week, and I will say this is one of the few things that you really want to be diligent about. And there are a handful of things in this presentation that you can do yourself. This classification is often not one of them. So I would find somebody with experience in employee or service provider classification, and make sure that how you're engaging your team members complies with applicable law, so you don't have fines or other issues down the line when you have more important things to deal with.
Absolutely. And Joe alludes to that this is an important point to take on and to look at. And, sometimes we get asked, well, how'd you pick these 10? They probably came from really two areas. One, the most common questions we get, and we interact with probably somewhere around 5 to 550 entrepreneurs on an annual basis, just talking with them, whether it be through office hours, presentations like this. And we keep track of those questions to see what are the most common questions we're getting. And that's how we came up with the 10 that you're seeing here today. I think the other thing, and this is the less fortunate part, is we end up seeing the worst in businesses sometimes. And what I mean by that is, we're at slide 6, and Joe and I could go through each one of these first 5 and tell you the horror stories of companies not addressing this. So whether it be a company not taking care of their operating agreement to really make sure they had that in place, and then there was a disagreement, and there wasn't a document governing that, or they didn't take the time to properly define the person's relationship. Oh, they're going to be involved, they're going to be an independent contractor, and we're going to vest them some ownership this way, and not taking care of that, and there being a disagreement. Or maybe taking care of it, not having the right documents, or not having the right elections, like an 83B election. We just see this over and over again. I just dealt with one where I have a very loyal client that I have told every year, we need to get your IP protected. We need to get your IP protected. And sure enough, they decided finally this year to protect it, and someone else has already filed. And so now we're having to deal with that. And so we bring these up because at the end of the day, it's so much easier to address it on the front end, to get it taken care of up front, because down the road, these problems end up being 4, 5, 6 times more expensive to unravel down the road because it wasn't taken care of up front. So as an example like this, to just make sure you get on a call, talk through the employee versus independent contractor, make sure you have the document with the right language is so important because at least in America, there's 50 states. Every state has different parameters around how this is handled. Every state has different parameters around how you handle restrictive covenants and non-solicitations and non-competes. And it's really important to understand that because you may not be in California, but you may have an employer, an independent contractor that's there, and then it's going to have different governing law than you happen to be in Texas, let's say, or you happen to be in Florida or Michigan or Illinois. So you really want to make sure, or vice versa. You may say, hey, I'm in California, and the laws that govern here, oh, that applies everywhere, and it's not the case. You may have more benefits in the Midwest or in the Southeast or on the East Coast than you have by traditional California governing law. And so those are just important things to take the time to look at because down the road, you end up with bigger problems than you usually want to deal with. And it's so important. And that's why we picked these 10 items to go through.
Yeah, so, 7, who's helping you? So we've talked about your team members. A lot of times you won't necessarily have individual team members, but instead you'll have partners. So we hear a lot about channel partners, dev shops, manufacturers, resellers. So in the event that you're engaging a third-party service provider, you really want to think through the details of what that relationship should look like. And often these negotiations can be contentious, but they don't have to be, because fleshing out the details of a relationship with a third-party service provider or customer helps both parties. So you want to be crystal clear on what the compensation is, when the compensation would be earned or paid, when the compensation should be forfeited or would be altered through the course of performance, and what services, including specific measurable deliverables and timelines, are being exchanged. So, neither party is going to be prejudiced if there's more details, right? If there is clear detail that makes sure that there's an agreement on how each party benefits and when those benefits are earned, or what the obligations are between the parties, it resolves any issue down the line in case there's a change in management, or unfortunately, sometimes there's a dispute. So when you're engaging a third-party service provider, you really want to be diligent about sitting down with them and fleshing the business deal out completely. And then if you have a lawyer, taking the business deal to the lawyer before the legal documents start getting drafted, so the business deal can be rounded out with any additional legal considerations. Just really important to think about these types of third-party relationships from both sides and just make sure they're as detailed as you can possibly get them, because filling the void later can be challenging.
Yeah, and I think just a sibling or a distant cousin to that slide about the employees and independent contractors, you're talking about relationships to the business. And, one step removed from that is your third-party service providers. And these people are an extension to an extent of your team. They're going to be assisting you in being able to deliver your products or services or be able to conduct your operations. And so, so often a client will be like, oh, I read it over, it looks great, and let's just go forward. And I think two things is, one is, if you don't know what to look for, of course the document will look great. So someone who's trained to look at that may find the 1 or 2 things that are missing, or the 1 or 2 landmines that are sitting in that document, that if you just weren't looking at that, you wouldn't know it. It'll read fine. Of course it's going to read fine. But those are sometimes the things, and we have a team that's all they do is review contracts, and so we review about 1,900 contracts a year, and really looking and helping clients to be able to understand that. I think the other thing that Joe alluded to is that there's never an issue until there's an issue, and making sure that the scope of work or what is being required, the expectations, is the most important thing. I get it early on in a business. We just got to get it done. Okay, get on the phone. Let's just get it done. Sign that. And they leave the lawyer out of that conversation. And then later on, they have a problem. They have to deal with it. And just calling up a lawyer and giving them hey, I need you to look this over for X, Y, and Z, or I need you to read for this is such a valuable set of eyes when it comes to these agreements. And all the time, my clients love to handle their documents themselves. And I said, spend the time to have me look at it. Spend an hour, or 2 or 3 hours on it, depending on the size of the document, because you're going to be governed by this document once you sign it. And whether it be the terms are too harsh to one party, or they're not explicative enough to understand what is really being delivered, is such an important part of that, and understanding what is each party's expectations going into the relationship.
And one last key on 7. I don't mean to interject, lawyerly negativity, but one thing that you also want to spend some time thinking about, which maybe you don't necessarily need to have as an open dialogue with your potential partner, is how the relationship ends. So sometimes it's helpful to think about how you would transition out of a relationship if you were to part ways, if there's a transition period, if there is a period where payment would continue for services rendered before the relationship was exchanged, if confidential information would need to be returned, if parts would need to be returned, if IP would need to be surrendered. So spend a couple of minutes also thinking about the deal with the end in mind as a principal concern, and that will also illuminate a couple of important business points. Key 8. So often the most interesting part of the presentation for a lot of people who attend these is, what's your fuel, right? You can have all the assets in the world, and you can have the best team in the world, and all of your legal documents can be bulletproof, but if you don't have a bank account with money in it to allow you to operate your business, you're probably not going to get that far. So, what's your fuel is really important. Where are you going to raise money? So first is be realistic about your burn rate and your runway, because it's really easy to raise money when you don't need it, and it's really hard and really expensive to raise money when you only got 2 weeks of cash in the bank. And I don't know why that's a rule, but it seems like that's a pretty hard and fast rule that holds true across industries and across company size or maturity. So just be really realistic about burn rate and runway, and it helps you avoid the situations where you're taking really expensive debt or you're raising at a low valuation because you just don't have money to keep the lights on. And then keep an eye on your cap table. So how much are you giving away? When are you giving it away? And who is getting what type of equity? So, fantastic publicly available reports from PitchBook or the National Venture Capital Association on, the age of a company raising a seed round, what the average valuation is, how big the raise is. Those types of data points can be really, really helpful when you're negotiating with somebody, whether it's a bank or an angel investor or a venture investor, on raising money and what that round looks like.
And often we'll have, people will say, well, they barely think they need a lawyer, let alone an accountant or a CFO or any type of intern financial services. And this slide is so important to just demonstrate that. Is, professionals like at Early Growth Financial Services can assist, and you can talk to them and bring a professional in to say, hey, how do I put together my projections, my pro forma? How do I make sure I understand what my burn rate is and really know my runway? How do I begin to understand how that money is going to be given up, and what do the terms need to look like, and how we're going to structure that, and what does this happen for my cap table? How do we do evaluation? All those things come into play on this slide, and it's so important. There is a legal and there is a financial aspect to that, and they connect very closely. And so, when you are getting ready to go down this road, you are going to want to make sure that you have a trusted professional that not only can help you with the legal side, but also someone who can assist with the financial side as well, because it's going to come into a situation where I just had a client where we were on the phone with the investor, and the investor wanted another iteration of the financials. So we had to go back and get with the finance team, and they put that together. And it went through a couple iterations before we kind of got to a point that they felt comfortable enough to say, okay, we'll move forward with an investment. It's really important to have those, because there are going to be questions. And, sometimes not knowing and saying, let me bring my professional in to assist me, is that it brings some comfort to the investor knowing that there's other professionals around, or if it's a legal document, bringing that that lawyer in to be able to explain the document or the terms or why it was done that way. Because we hand you a document sometimes, we don't expect you to understand why every clause is in there or why every subsection is in there, but that's a great time to demonstrate the depth and breadth of your team, that you do have accountants and lawyers or financial people around you to support you as you're going out for that fundraise. Because if someone's giving you money as an investor, their mindset's going to be looking at, is this team investable? Do they have what it takes? And if they don't have their foundation in their legal and their finance, that raises a red flag for some investors.
You obviously have to raise money, so the type of money that you raise varies widely. Is it friends and family money where the company can dictate the terms and you're not sitting out there probably paying somebody 10% interest? Is it an angel investor where you really need to start to be diligent about making sure the terms that you're talking about are market terms? Or is it an institutional investor where the company can offer all the terms that they want? Even in a good market, an institutional investor still has internal fund requirements or goals or portfolio composition concerns where they're going to dictate a lot of the terms of a raise. So you're not often going to go offering a safe, even a Y Combinator form of safe, to an institutional VC for $500,000. You're also probably not going to offer preferred equity, preferred stock, to a member of a friends and family round, right? So you really want to think about and honestly read up on safes and convertible notes and preferred equity rounds. And there are fantastic venture capital blogs, like both sides of the table. The National Venture Capital Association has great resources for safes or KISS agreements. You can look at 500 Startups or Y Combinator's websites to get great FAQs on those documents. And you really just want to understand what the terms of the proposed financing are. So what a safe does to your cap table, what equity or what debt does to your cap table, how taking a $500,000 check from your friends and family can impact your future rounds, and how much money you want to take from a VC without getting completely washed out, right? There's a strategy to what kind of money you're raising and when you are raising it.
And I think one other thing to just look at that when you're talking about that is, we're lucky we're in the middle of the country, and so we get both coast deals coming in. We get to see them, and depending on where you are, the types of investments, the types of terms really do vary. I think Joe alluded to there's some great standard reports that you can look at to benchmark against, and I always recommend these are free reports. If you ever need it, contact us. We can let you know before you get into a deal to kind of understand some general terms is always valuable to understand. And it's just to understand the mindset of the investors of who you're dealing with. And so depending on who you're asking and where you're asking in the country, it's going to really change. And it's interesting. I'll get calls from different areas, or I'll be traveling to different areas, and people will say, what's the climate like here versus there? Because it is really different. And knowing that can be important, because if you're going out with a certain set of investors in mind and your terms are all off, you're going to probably get a lot of no's and not understand why. And so really being able to understand that and having people on your team and professionals who can assist you in the negotiations is an important aspect of that. And the last part of this slide, before we hop on to 10, is looking for money is a game with rules. There's securities laws. They include rules around general solicitation that are important. It's going to be really, really important you understand what filings need to occur. Some people are using crowdfunding. Some people are going to family and friends. Other people are going to more institutional. Just depending on where you're going, whether it be accredited or unaccredited, you need to understand the rules that are governing what you're about to do. We do a monthly pitch competition where we fund companies, and we always tell them before you get up there, please do not give or ask for money. Give the terms of your raise, because we don't want it ever to be construed as public solicitation. It seems like such a small thing, but it's such an important thing that you just want to avoid doing anything that would break any of the regulations, securities laws. So we always instruct people really just to make sure you understand that you do the right filings along the way, because there are legal implications to that part.
Yeah. pretty important that you comply with securities laws. And we have a lot of people that say, well, I'm raising too little money for anyone to care. So that's, totally fine. And a lot of people take that approach. That doesn't mean that it doesn't come at a cost later. So again, this is another one like independent contractor versus employee classification. You want to be diligent in understanding what your obligations to register your securities are. It's just another red flag, right? You don't want to give investors a reason not to invest in you, and this can be one of those issues.
And again, another one as we wrap up, this is a perfect example where it doesn't seem like a big deal to it is, and you're probably right, a lot of them don't. But I can tell you just today I'm dealing with one where all the right filings hadn't happened before we got involved, and now we're undoing a mess that could have probably been resolved had it been done with on the front end in probably 2 hours. It's going to be a pretty long, drawn-out process now that we have to deal with. And so just another opportunity, just do it right up front. And the last one is who are you? And sometimes people will say, why isn't this on the first slide? This should be the first slide. We understand that branding is key and really understanding what your brand in. Are you protecting your company name versus a product name? Sometimes it's important to go out and get that trademark clearance and make sure you understand. We have clients that will come to us and say, hey, we're thinking about going down this road with our brand and with our company. What do you think? And we start to really understand, is this a brand they can actually secure and protect or not? So it's really important to understand that so that you are getting the right social media channels, that you are getting the right URLs, that you are protecting those assets that are going to be associated with your brand. Because without it, you're going to have a hard time. It's going to be expensive to go buy that domain or to go back and say, well, wait a minute, we wanted to use that name and now someone else is. So it's important to understand where your brand is and what you need to do to make sure you have all the branding and the URLs around that.
So I mean, a lot of people punt on this. I think it's a lot easier to go through the who you are discussion up front, especially on the company name versus product name and trademark clearance. It's a great problem to have when you're growing really fast and you're just trying to manage customer demand. It's a really unfortunate problem to have, to be growing really fast and then to receive a cease and desist letter from somebody or realize that your name is unprotectable. And this goes back to what you have as an asset. If you can spend a little bit of extra time up front carving out a niche and knowing you have a defensible brand, then you'll never have to worry that your marketing spend is building a brand that may not exist at some point in the future through no choice of your own. So I think, branding is something that we honestly counsel people about with every single formation that we do. I would say probably 30% of the companies that we work with will have us do some in-depth trademark searching and looking through USPTO records to see if a name is available. But of that 30%, nobody has ever come back and said, man, that was a waste of time. So, do a little bit of branding work up front, do a little bit of consultation with some of the people that that are good marketers, and just make sure that you're carving out a niche that you can defend if you need to do it, so that your brand equity is really a key part of your asset base.
So with that, we'd like to open it up to the audience. We thank everyone for attending, and this would be the chance for us to go ahead and do questions, and Joe and I will answer anything that we can for you.
So we do have a couple questions that have been typed in. The first question is, if you want to seek venture funding but are currently incorporated as a California S corporation, how difficult is it to convert from a California corporation to a Delaware corporation, and what is the process like?
So it's not very hard, which is a good thing. So a lot of the states recognize that to be a public company one day or to raise a lot of money, Delaware is kind of the gold standard. So many states, Michigan included, California included, actually have mechanisms in their corporation law or their limited liability company acts that define the process for converting from a corporation or an LLC in state A to a corporation in Delaware, right? So in this case, California corporation to a Delaware corporation. So there are some forms you have to fill out. Unfortunately, it will cost a couple of $1,000s in filing fees. So you obviously, California makes you pay them to leave. Delaware makes you pay them to come there. There are going to be some attorney's fees associated with the conversion. And then with the termination of your S corporation election, you would really want to work closely with your accountants because as a pass-through entity, you'll have to file short form returns, which wrap up your pass-through tax treatment so that when you become a C corporation in Delaware to raise money and your tax treatment changes, that the pass-through tax treatment is appropriately terminated. So a little bit of work on the CPA side, a little bit of work on the legal side. It's all relatively straightforward. It just costs, a couple $1,000s, and a lot of that is going to be, again, filing fees in the states of California and Delaware.
Great, thank you. So somebody actually had a follow-up to that and asked about Wyoming. Is it similar for all states?
Most states have similar approaches. It's hard to say without looking at each one. I haven't done a Wyoming conversion, but most states will have defined mechanics to go from being a quote-unquote domestic entity, which is a Wyoming company if you're in Wyoming, to being a foreign company, which would be Delaware or Michigan or otherwise. So often very similar. Every state, though, has nuances. New York is very different than Michigan. Florida is different than California, but the processes are pretty well defined. And if you actually just Google, Wyoming corporation conversion or look at the Wyoming Secretary of State's website, most states have very helpful, frequently asked questions, and you can get some good guidance just from those publicly available websites.
Great, thank you. Next question is, can you repeat the source that you referenced to learn more about investments?
Sure. So there are a lot of different really good sources. The first one is the National Venture Capital Association, so the NVCA. They co-publish lots of really good research reports on a quarterly and annual basis. Another one is PitchBook, so one word, PitchBook. PitchBook has fantastic newsletters and also co-authors great quarterly reports. I honestly tell people that you can, another Google reference, you can Google venture capital surveys and reports, and you will find, dozens of really recent, really helpful charts and reports on the state of the national and international venture capital industry. And a lot of those reports will also have breakdowns by industry, company stage, and different factors that are relevant to your specific criteria. So PitchBook and the National Venture Capital Association are great. Also, various state-level venture capital industry associations, like in Michigan, we have the Michigan Venture Capital Association publishes an annual report. So that's why going to Google and really looking, broadly can help you a lot.
Perfect. Thank you. Next question. What degree do you advocate C Corp and the associated QSB 1244 and 1202 opportunities versus LLCs?
So this is an interesting question because, you get different investors that want qualified small business stock treatment or 1202 treatment for their investments. And a lot of those folks are ultra high net worth or high net worth individuals who want certain tax preference treatment on their equity. There are lots of restrictions on this, though. So we see it come up, certainly not in all equity investments, but in a number of equity investments in early stage companies. And the reason I say early stage companies is one of the restrictions on qualified small business stock treatment is that you have to have an asset base of a certain level. I believe it's below $50 million. There has to be certain holding period requirements for the investors. So I believe that holding period for most investments is 5 years. So if you're investing in a Series C, your goal is to get out before 5 years, right? And a Series C company is going to have too short a holding period for your stock and is probably going to be too big by the asset test. So you want to be very diligent about working with your accountant and a tax attorney, if you're on the company side, to make sure that you can promise your investors qualified small business stock treatment and that you understand the requirements of a qualified small business stock investment so that you can tell your investors what is required. I believe that treatment is only for early stage stock in C Corps. I don't think it applies to S Corps. I would have to check that, but we see it frequently. We see it from sophisticated investors, often angels who are very high net worth, so $50 million and above, because the liquidity requirements or the liquidity restrictions sometimes are a deterrent for others. And we generally don't see venture funds that are particularly interested in it, especially because their holding period's uncertain. So we could go, deep down a rabbit hole of tax treatment, but short answer is we do see it quite a bit. Heavy restrictions on how you get that treatment, and the issuing company really needs to be diligent if they see a qualified small business stock representation in a purchase agreement, that they understand what that means.
Perfect. Thank you. Next question is, have you worked with companies that have done ICOs? And what have these companies done to consider the legal, accounting, and tax implications?
So, and we should have said this earlier, this should not be construed as legal advice, and this is simply a webinar, so you still want to definitely consult with whoever you choose as your counsel. ICOs right now are a very hot topic and a very exciting topic. There are some people that are very much for it, some people are very much against it. There are certain regulations that you need to comply with in offering an ICO. When you go forward, obviously for those who are unfamiliar, an ICO is basically like an IPO, but it's coming out of the crypto world, cryptocurrency, and you're still doing an offering. In the case of a public offering, it's a offering to the cryptocurrency world, and so it's very important to make sure you're complying. I think I heard some staggering statistic, like it was 60 or 70% of all ICOs are considered scams or frauds that are out there right now. There's a lot of mixed reviews around doing an ICO and how it gets done, to say the least. Some people absolutely love them, some people don't. The ones that are done right obviously can have very, very, very high yields as far as what gets raised. I would say significantly higher. I saw one statistic that ICOs have raised more than were raised by ICOs, funded more this year so far than VCs had funded into deals. Again, I can't recall the source on that, but I had saw one article that alluded to that. So there's a lot of money being passed through that. Right now, I think the market cap is something like 315 billion in cryptocurrencies, and so it's getting up there, and they're expecting it to go up to $1 trillion. So there's a lot of people that say cryptocurrency is not going away, and ICOs are going to continue to go. They are right now looked at by a lot of people as one of the more risky ways to do that out there, but there are a lot of advantageous reasons for doing that. And I would just say, just like going back to that slide, you need to have all your ducks in a row. I can tell you that it's probably anywhere from 10 to 20 times more, at least 10 times more expensive to do an ICO from the groups I've been talking to that have actually gotten one done successfully than the ones than doing sometimes a traditional raise that would fall under one of your Reg D exemptions. And so it's definitely probably a Reg D, then A plus, and then going up to the ICOs as far as kind of from the level of expenses associated with doing an ICO. So great question. Joe, did you have anything you want to add to that?
No, I mean, I think that's correct. Just ICOs, we see them as having kind of passed their fever pitch a little bit. And yes, I would be very, very wary of the SEC enforcement trend, which is pretty significant. Mm-hmm. We've seen a lot of investors back off from interest in ICOs, just as an initial matter.
Great, thank you. Next question. We are a small startup and likely to pursue venture capital at the moment. Is there a way to determine ability to trademark without a lawyer or legal representation? If not, what fees tend to be associated with this search?
It's a good question. So, typically, I always tell this of anyone with IP, even including like a patent, I say start with Google and go there and look. That's going to be one of the things we're going to look for to see if someone else is out there or has any common law rights to what you're looking to do. If you go out to the internet and you can't find it, you go to a domain registry and you can't find it, that may be an inkling that someone else already owns it. If it is available, that's a good sign, and definitely start by scooping that up, the domain at least, so you have that in the emails. The other thing is Joe, I think, alluded to when he gave USPTO, United States Patent and Trademark Office, so uspto.gov is the site you would go to, and basically you can go in there and you can do a search. So it is open to the public. I will say that is, you're probably conducting a search that's going to give you a tip of the iceberg, because it isn't just an absolute search where here's my word and let me make sure no one else has that. There are a lot of other ways that you could get what's called an office action, or you could be stopped from securing your mark. So understanding those strategies is really where the attorney comes in, is really understanding how to think like an examiner, how to be able to position your mark in such a way to get it through the examiner. Once you do file, going online to file, you can do that. Typically, there's a filing fee, so each good or service has a class, and it's usually by class. So depending on how you're filing, it can be a few $100 to $300 per class. So if you're $325 for a class, you had two classes, your costs associated with filing fees alone would be $650. That's what would go into it. Depending on where you're looking, you can find some services online that will advertise that it's a few $100s to file your application. What they're really telling you is just to file the application. What they're not telling you, and this is something I always share with clients, is that the trademark process is usually a 9 to 15 month process that starts with an application, typically turns into some type of office action, and then from there we'll typically have a period where it gets published to the Gazette for opposition, and then a wait over period to when you actually have the registered mark. And so that entire period will range in price. You'll see some firms that do that hourly. You'll see some that do that on a flat fee basis. Kind of the spectrum is you can find someone who will just file your application online for a few $100 plus filing fees. Typically, you'll find, you should typically about a couple $1,000s on a flat fee basis to do a trademark for giving one class, and then you can go all the way up to the hourly, which I've seen, those range from $3,000 to $6,000 depending on where you're at. So it really depends on what type of support you want from your professional in that process, and exactly what you're paying for when you go through that process. Great question.
Thank you. Next question. My company is incorporated and about to open a business bank account. We'd like to deposit our personal savings into that account before seeking any external fundraising. We aren't looking for additional equity based on these deposits. Is there an official process to go about this, or is it just as simple as depositing the funds?
So when you say, and I guess, there's a couple follow-up questions of, I mean, if you have an EIN number for your company and you are allowed to open the bank account, that they'll ask for an initial deposit. So a couple of things there are, when you deposit that money into the account, it is no longer your money. So, you want to be diligent about not putting $200,000 or $100,000 or $50,000 into a company, because you can't just take it back out without considering how that would be accounted for, right? If the company pays you, is it a dividend? Because a dividend is taxed. So once it's in, it's the company's, which reinforces a point that everybody always wants to keep the company's finances, whether it's an LLC or a corporation or otherwise, separate from your personal finances. So, is there a way that, is there anything special that you need to do to make that deposit? No, but you would just want to work with your accountant to make sure that that's just an initial capital contribution if you're an LLC, which, flows through to certain LLC returns, tax returns, or you're appropriately referencing it as an asset and like a paid-in capital deposit for a corporation. So you want to be, really diligent about how it's taken care of on the accounting side, but on the practical side, no. If you want to put however much money into your company, go ahead and do it. Just realize it can't come back out as easily as it went in, right?
And one other thing that I would just say about that, and obviously all banks are governed at a federal level for the most part. So there are some, I'm finding that most banks are saying EIN, state documentation showing the entity was formed in good standing, and then a lot of them are asking for an operating agreement or a shareholder agreement. A lot of them will want to understand how it's governed or who has rights to this account or who has rights to control the account. So I find that most of the time the banks are asking for that. I can't say absolutely across the country every bank's going to ask for that, but that's been my experience, from here to Texas and Florida. I know that I've had those different no matter where I've been for those. Good question.
Okay, so I think we have time for about one more question, and then there's a couple more still in here, but I'm going to send a follow-up email to everybody, and if you have any other questions that haven't been covered, I will go ahead and include contact information on that email, and you can reach out that way. So last question, could you talk about QSB 1244 treatment?
And I think, so is that a duplicate of the qualified small business stock question from earlier? Because I think there is overlap in the QSB and qualified small business stock too.
So we're probably covered there.
If not, whoever asked that can definitely email us and we'll be more than happy to talk to them about it.
Great. Yeah, I think most of these questions right now have been pretty much covered. So we can wrap up there. Any closing thoughts before we say goodbye?
No, I mean, I think everybody just, take advantage of the free resources that are out there. There's a lot of great stuff on, venture capital association blogs, venture capitalist individual blogs. Just read up. Don't take any one source or any one opinion as kind of the final opinion, but educate yourself before you make decisions, and it'll save a lot of hassles down the line.
And the last thing I would just say, kind of in closing, is the professionals are there to help you. They're there to guide you. Utilize them. Consider them part of your team. They should be a trusted advisor to you, no different than you have a mentor. You should be able to find an accountant or a lawyer that is willing to work with you and sees the value in growing your business with you. And finding someone can be one of the best opportunities to help you grow and create success in your business moving forward.
Great. Thank you so much. Thank you to Bodman and to Michael and Joe. That was a great presentation, and we will follow up with everybody via email. Thanks so much.
Thank you.